Hi, this is Chavez and Volko. We are a full service immigration law firm. We do everything from deportation defense to EB-5 investments and everything in between. My name is Ben Hamilton. I am a senior associate attorney managing our employment-based practice. So today we're going to talk about employment-based immigration law, specifically the H-1B visa and CAP registration. I am here with Associate Andrew Craven. Say hello, Andrew.
Hi, everyone.
So we're going to be talking about CAP because it's CAP season. I'm going to be asking some questions to Andrew, testing his knowledge as the newer of the attorneys in our office working with our employment-based cases. Just as a little precursor, the H-1B, what is it? It's a specialty occupation, meaning it allows U.S. employers to petition for workers in positions that require a specific degree. The problem is that they only give out 85,000 new ones a year. And of those, 20,000 are reserved for people with U.S. master's degrees. So we're looking at 85,000 slots. Last year, there were 274,000 registrations. So what does USCIS do? Well, they do a lottery. And so we're going to talk about how that registration and lottery works because it's actually ongoing right now. So, Andrew, right now, we're currently registering people for the H-1B lottery. When does registration close?
At noon Eastern time on the 25th. So we got a little less than a week left.
That means if you are interested in registering for the CAP, please call us or go online. You can actually set up an appointment online to talk to us, but the sooner the better. Second question, can I register myself for the CAP or does my employer have to do it?
It has to be the employer. So you can't self-petition on an H-1B, but as many employers as you can get interested in you can petition for you in the H-1B CAP.
So what information does my employer need to register me?
From the individual they want to employ, they basically need your passport, the biographical page, which is going to include your name, your date of birth, the passport number, and your current country of citizenship. And they're also going to need to know what country you were born in.
Does it cost anything to register?
For the employer, it's going to be a $10 registration fee.
And this may be one of the reasons why cases have shot up last year and may go up this year, is because in previous years, everybody had to submit their full application with fees day one, but now you can just register online and pay a $10 fee. So the barrier to entry to the registration is pretty low. So when will I know whether or not I've been selected?
You should know by the 31st of this month.
And how will I know?
After everyone is registered, they're going to run the lottery, figure it out, and then whoever has won will find out on the 31st by email.
Great. So, are there any way to improve my odds? I mean, I'm looking at 274,000 people, 85,000 slots. Your odds are somewhere in the 20 to 30% range. Is there any way to improve my odds?
So like you were mentioning before, 20,000 of those slots are reserved for folks with a U.S. master's degree. So the best thing you can do is have a U.S. master's degree. Second to that, just get as many employers interested in you as possible.
I guess the key thing here is an employer cannot register the same person twice, but the same person can be registered by multiple employers.
Right.
Okay, so if I find out on the 31st that I have been selected, how much time do I have to file?
You're going to have 3 months, so 90 days.
All right, so if I'm approved, when does the H-1B start?
It starts at the start of the fiscal year for the government, so October 1st.
So let's just say I graduated and I got F1 OPT, so I'm working here on my OPT. Well, for most people, my OPT is going to expire in the summer, right? Because that's around when I graduated, June, July. If the H-1B starts in October, do I have to leave the country? What can I do?
For that, you're going to do what's called cap gap. So you're going to work with your school's Department of Foreign Students, let them know what's going on, and just get your OPT extended for the summer based on the fact that you have a pending H-1B petition. Sorry.
Yep. I mean, so the basics are if you're selected and you file before your OPT expires, right, you can get it automatically extended up until basically October 1st, so you're covered. But what if I'm out of the country? When can I apply for the visa and when can I enter? I mean, can I enter in September with an October start date? How does that work?
So in terms of the visa, you can't get the visa until you have the approval, and then you can enter the country starting on October 1st.
But can I enter anytime before?
Sorry, I'm pulling a blank, Ben. What's the grace period before?
So typically you can apply for this is what we're playing is Stump the New Guy, right? So typically you can apply for up to apply for the visa 30 days before your start date and enter 10 days before your start date. So that's kind of, obviously, they give you a little bit of leeway. They just say, hey, for some people, it takes a little bit of time to get in, get set up before you start work, right? So next question. If I'm not selected, am I just done? Or is there somehow another opportunity for me under the same registration?
Under the same registration, it just depends on how many cases are not approved or how many people, after they win the lottery, just don't file their petition. So after that 3 months, there's a period of time where they're going to look, and if they still have visas to give out, they will continue to approve people in this registration. And so you'll know for sure by October 1st.
Yeah, so this actually happened to us last year where, what happens is USCIS selects 85,000 people, but then they receive less than 85,000 applications. And so they rerun the lottery. And so we had some people get selection notices, I think it was in August, which was kind of a nice surprise. So if when will my case at any point ever be sort of officially closed, where like I actually get a notice that I have not been selected?
So on this last round, what we saw was that people didn't get their full final official notice until right before the start of the next registration. So you don't actually get a final notice until then, but generally by October 1st.
Yeah. So basically what happened is people got selected, got a selection notice. People that didn't get selected didn't get anything up until last month. USCIS was cleaning up their database and started issuing actual rejection letters. And they didn't warn anybody, and everyone was kind of confused because we kept getting these status updates and like, what's going on? And then we figured out what the problem was. So H-1B visa cap is open through March 25th. So please, if you haven't, go online, set up an appointment, talk to us, right? So we can help you, your employer, whoever, set this up. Next week, we're going to talk a little bit more in depth about, like, once you've been selected, what kind of goes into actually filing, right? But for now, we're going to talk a little bit about some H-1B news. So USCIS issued an alert recently that's entitled, USCIS may reopen H-1B petitions denied under 3 rescinded policy memos. I have to say, this was like a huge surprise to see USCIS proactively come out and say, hey, we rescinded these memos. We may have denied some cases. You can maybe come back and get them reopened. It was like, wow. So I guess the first question is, we got to look at what are the names of these 3 memos that they're talking about.
So the 3 memos that they're talking about are determining employer-employee relationship for adjudication of H-1B petitions, including third-party site placement. That's essentially just getting into companies that do outsourcing. The second is contracts and itinerary requirements for H-1B petitions involving third-party work sites. And then there's the rescission of the December 22nd, 2000 guidance memo on H-1B computer-related positions.
Yeah, so at the end of the day, the focus of these memos was really going after the companies that are doing outsourcing, like the IT outsourcing companies, focusing on the third-party worksite, who is the end client. They want contracts from the end clients that show that the work that the end client is offering also qualifies as specialty occupation. They also wanted to see itineraries. And of course, these memos were used under the Trump administration to greatly increase the denial rates. We saw denial rates go from around 60% to over 29% on average, and certain companies saw their denial rates go up to 50%. These would be a lot of the IT outsourcing companies, a lot of these Indian IT outsourcing companies, like Cognizant, Infosys, Accenture. They saw their denial rates just skyrocket under these three memos. Well, these three memos were all rescinded. Part of this had to do with some litigation. Basically, the government was sued, saying that these memos were not lawful, nor were they implemented correctly. They didn't go through the Administrative Procedures Act. USCIS, I think, kind of saw that they were going to lose, so they came to a settlement where they decided to rescind these memos. Now, the Trump administration did attempt to then reinstate them through the rulemaking process, but Biden won. The rule didn't come into effect, so now it's gone. So they're saying we may be able to reopen. How does that work? How would we reopen one of these denials?
So essentially, at that point, you would have to file what's called a Form I-290B, which is just an appeal, get the process started.
How much does one of those cost?
$675 is the filing fee.
And how long does it take?
So right now, the process is taking about 6 months to upwards of a year.
And that's kind of one of the problems here with the 290s is there's actually, whereas almost anything else with USCIS, you can go on and see what their stated processing time is by form and by service center location. They don't post any processing times for the I-290s. So we never know how long it's going to take. We've seen them take as little as maybe 6 months. Most seem to take over a year. And we've seen some take even longer. Like, it seems USCIS kind of forgot about them, and we had to kind of go and remind them that they had this sitting out there. But they're saying we can file these appeals, but isn't there a statute of limitations? Isn't there a rule in terms of when you have to file an appeal?
Right. So typically that's 30 days.
So if it's been more than 30 days, are there any exceptions to the rule?
Yes, there's a legal theory known as nunc pro tunc, which essentially allows you to request a late filing to have it forgiven. And in that case, or I guess in this case, we would blame USCIS error is the reason for that nunc pro tunc exception.
Yeah, and the good thing here is that in the alert, USCIS alludes to a nunc pro tunc. I actually have the quote here. It says, USCIS has the discretionary authority to accept and consider untimely motions under certain circumstances, as explained in the form instructions and permitted by regulation. So they're actually acknowledging nunc pro tunc here, which means they're more typically getting USCIS to accept the nunc pro tunc can be difficult, right? They don't want to. You have to have a really good excuse for the late filing, but it seems like here they're implying that maybe they're going to be a little bit more generous when it comes specifically to these cases. Are there any other options than just filing an appeal straight to USCIS?
Other than that, you could just appeal straight to federal court, at which point USCIS would have 60 days to respond to it.
And, it can sometimes cost a little bit more depending on legal fees to file something in court. It's not always the sort of preferred or first option, but it can sometimes be the most effective depending on the case. Because whereas with filing with USCIS, it can take 6 months, a year, who knows, when you file in court, they're on a 60-day clock. And more often than not, you know, they don't want to try to fight you and litigate this, right? They just, oh, okay, we'll reopen it, and get it reopened in 60 days. Maybe reopen and just issue an approval. Maybe reopen and issue an RFE. So that, you know, this memo is a pretty big deal, especially for, you know, people in those that were denied, right, under those memos. Again, largely impacting people who work for outsourcing companies, were the ones who were denied. So now we're going to move on to the question section. We're going to see if we can stump Andrew here, ask him some common H-1B questions. And then, like I said, next week, we're going to talk a little bit more in depth about how the H-1B actually sort of works in terms of preparing for the actual filing. So here's some common H-1B questions. I currently work for a CAP exempt employer, right? So there are certain employers that don't have to go through the CAP and registration process. I've been offered a job by a non-CAP exempt employer. Does my new employer need to register me for the H-1B CAP?
Yes, they absolutely do. If you go to work for a CAP exempt employer, then as soon as you go try and get a job with a non-CAP exempt employer, they would have to go through the whole CAP process.
What's an example of a CAP exempt employer?
That would be something like most universities hiring professors or folks of that nature, and some nonprofits that are also connected to institutions of higher learning.
Yeah, like you see a lot of research institutions that are connected to universities also qualify. So here's another question. The job code with my current H-1B employer is ABC, whatever it is. I have a new employer, and they're recommending doing job code XYZ, right? Different job code. Is this going to be a problem?
No, the job codes are not really tied to you as an individual, right? But they're tied to what fits the job description best of the employer. So, common job code 151132, right? All the software developers. Uh, if your new employer wants you to do some other form of programming or another computer related job that would fall under, I'm going to say 151199. That just means that the job description of the new employer is different. That doesn't necessarily affect whether or not they would require someone with your credentials.
Yeah, the important thing is that like the job code is not attached to you. It's attached to the position being offered by the employer. And what matters is that you have the education that lines up with that job code. So certain educations can, you know, apply across 3, 4, 5, multiple different job codes. So next question. I was just laid off. How long do I have to depart the country? Do I have to leave immediately, or do I have time to find a new employer?
So you have a grace period of 60 days, and within that 60 days, you have to find a new H-1B employer. Otherwise, then you will have to depart.
What if I quit? What if I'm not fired, but I quit? Do I still get 60 days?
Yes.
Uh-oh, I think we stumped him.
Yes.
The answer is yes. Yes, you still get 60 days if you quit. The way it's written, it doesn't really matter how it is. Okay, next question. We're going to talk about amendments. All right, I was just promoted or got a salary increase. Does my employer need to file an amendment?
Well, that depends. Was it in any way a material change in your job description, or is this just regular pay raise or a regular promotion?
Yeah, exactly. The bigger question would be like, would my job code change, right? If I'm a software developer 1 and now I'm a software developer 2, but I'm still a software developer, then no. If I'm a software developer and this is going to be such a promotion that now maybe my job code would be under software managers, then maybe, right? But it really depends on whether or not your job code would end up changing. Most of the time, sort of like one-step promotions don't require an amendment. But again, we do have to kind of look at each case individually. Okay, next question. We just moved offices. Does my employer need to file an amendment?
Again, that depends. Was it within the same region, the same MSA, basically, did you move so far that the prevailing wage might have changed and you might need a new LCA, or are you moving down the street? And that would
Yeah, so
determine.
typically, down the street is no, it's in the same MSA. But like for us, if we're in Dallas and we move to Houston, then yeah, that'd be a different MSA and you'd need an amendment. Here's the trick question. If I move, but it's still within the same MSA, is there anything I don't have to file an amendment, but is there anything I have to do? We stumped them again. You have to post the LCA for 10 days. So just like when you do the original LCA, you have to post it at the job site location. If you move, you still have to post the LCA, even though you don't have to file an amendment. Next question, really important to right now. I now work from home. Does my employer need to file an amendment?
So this does go back to, it's a new location for the work site, so you would still have to post a new LCA, and then presumably you're living close enough that you don't have to file an amendment. But if you,
So if it's still within the same metropolitan statistical area, that's the MSA, then I guess I put the LCA on my fridge for 10 days, right? And I can still work from home. So yeah, again, it's an analysis as whether or not there's been a material change. So a change to a job code, right? A change of an MSA are kind of the two major ones. So what we typically tend to see with a lot of people is when they're doing outsource work, they're working for employer A, is the end client in one city, and then maybe that job ends, or they get a second job with end client B in a different city, right? And then of course in those cases you'd have to file an amendment. Okay, next question. This is a cap related question. I had an H-1B in the past, or I was selected in the cap in the past, but maybe they changed to a different status, or maybe they were here and went home. Does my employer need to register me for the H-1B cap?
as long as you got your H-1B, activated it, so to speak, that is, if you're within the country and you win the cap, within 6 years, if you've changed status and want to go back to being an H-1B, then they don't have to go back through the cap. Now, if they got their H-1B and they needed to go to the consulate to get it, and they never went and got it, then we enter a gray area where it's kind of up for debate.
Yeah. So, I mean, yeah, the first analysis was how long ago was it? Was it within 6 years? And then secondly, did you quote activate it? But that whole activate thing, yeah, is a super gray area. And we've specifically had a client that got it approved when they were abroad, never applied for the visa, right? They actually ended up coming in on an L, and then they wanted to go to a new employer, so they had to do an H, and we kind of warned them of what of what the possibilities were, filed it, and it got approved. And I've seen anecdotal, stuff from attorneys and clients kind of going both ways, as to did you activate it, did you not activate it? It seems to be a super gray area there. But within 6 years, of course, that's pretty concrete. All right. My company has offered me stock options. Typically, the H-1B is not for self-employment. My company's offered me stock options. Is this going to be a problem? Is this allowed?
It's allowed. It is something that you're going to need to divulge during your next renewal, but you can have ownership just as long as the employer still has control over whether or not you can, be fired, and general control of you as an employee.
Yeah, as long as you maintain the employee-employer relationship, you can receive stock options. Now, obviously, if you were just to like buy the company or somehow get a majority share, that'd be a problem. But if it's like a couple thousand shares or 1%, whatever it is like that, it's actually not a problem. You do have to disclose it, but it shouldn't be a problem. And here's a really common question, and this is, I'm going to say straight up, very gray area. Can I have a side hustle, such as Robinhood, Airbnb, Turo, you name it?
I mean, when you initially said side hustle, I was going to say you got to get approval before you do any other kind of work. And the emphasis is on work. So whether or not you can have property that you're renting out, the important question becomes, is it passive, or is this something that you're actually working on? If you just want to, say, own a house and rent out one room, I would say as long as it's a very passive thing, it might be okay. Uh,
Yeah, I mean, I would kind of look at it. One of the things is to say, could I do this as a tourist? Is kind of one of the questions to ask yourself. And yeah, like you said, when you say hustle, that kind of like a side hustle implies work, as opposed to like a passive income stream. Passive is always fine, right? So like if I'm investing my own money in Robinhood or Webull, playing the stock market with my own money, yeah, that's fine. That's your own money. Um, could I own a property? Like, could I buy a home and just rent it out? Most people would consider that also like a passive income, right? But then next thing you know, it's like I got 6 or 7 properties, and it's like, well, then at that point, you would probably need to hire somebody, right, to manage it for you, and then you just continue to receive passive income. It's the same analysis of like, well, I can own a business, um, and as a tourist, but I can't actively manage it. I couldn't receive a salary from the business, but I could, if I had someone who's managing it for me, I could receive dividends and profits. Again, it's a bit of a gray area now when you start looking at stuff like Airbnb and Turo, where it's kind of like, well, I mean, I can rent a room in my house, which is probably fine. That's passive. But what if I like buy a house and I start renting that house? Or what if I rent my car, which it's primarily my car, but I rent it on the side? Or if I am buying a second car and all I do is rent it, that kind of goes from sort of a passive sort of side income to like a business income, right? That's why something like Uber or Lyft is just like, no, that's not going to work at all. That's definitely like, contract employment. Again, it's a gray area. You should always be cautious. You should always probably try to reach out and get some help, talk to an attorney, say, hey, this is what I kind of have in mind. Is this going to get me in trouble? Is this passive, or is this going to be construed as work, right? So like I said, huge gray area. So we've kind of run out of time for today. Talked about the H-1B registration, this new memo, answer some H-1B questions. Next week, we're going to dig a little bit more into the weeds in terms of the actual H-1B application. What is the employer going to be wanting from the employee? What are they looking at in terms of like job codes, prevailing wage, kind of what to expect? Answer some more difficult, more nuanced questions. Just remember, right, you can go to our website, book an appointment. You can, obviously call, set up an appointment to talk to us. The other thing to remember is we have an amazing app. It is called the Law Pilot Guardian. It is a great app you can download for free. It's got a lot of cool features that are also for free, like a whole section on Know Your Rights in English and Spanish. We get notifications sent about immigration updates. There's also a cool emergency feature. So take a look. Download, go to the website for more info and details. Go to our website. You'll see more info there about the Law Pilot Guardian app. Otherwise, thank you, Andrew, and we'll see you guys next week.
Appreciate you, Ben. Bye, y'all.
Bye.